ಆಯ್ತಾ? ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇದೇನು ವಿಡಿಯೋದು ಇದಾಗಿದೆಯಲ್ಲ? ಇಲ್ಲ ಹಾಗೇನೆ?
ಇಲ್ಲ ಮೇಡಮ್.
ಅಲ್ಲಿ ಆಡಿಯೋ ಪಕ್ಕ
ಅದೇ ಇದನ್ನು ಕ್ಲಿಕ್ ಮಾಡಬೇಕು.
ಮೇಲೆ ಮಾಡ್ಲಾ ಕ್ಲಿಕ್? ಸದ್ಯ ಕ್ಲಿಕ್ ಮಾಡಿದ್ರಾ?
ಬಂದಾಗ ಮಾಡ್ತಿದ್ವಿ ಮಾಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ
5 ನಿಮಿಷ ಇದೆಯಾ? ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ 5 ನಿಮಿಷ ಇಟ್ಕೋ. ಕರೆಕ್ಟಾಗಿ ಪಾರ್ಟ್ ಟೈಮ್ ಆದ್ರೆ ಆ ಟೈಮಲ್ಲೇ ಏನಾದ್ರು ಕೈ ಕೊಟ್ಬಿಟ್ಟು ಅಂತ ಅಷ್ಟೇ.
ಅಮ್ಮ He was very happy. ನಮ್ದು ಅಲೋ ಆಯ್ತು ಅಪ್ಲಿಕೇಶನ್ ಹೌದಾ ಇಷ್ಟಲ್ಲ
What up, sir? What up, sir?
ಫೋಟೋ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಮೇಡಮ್ ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 34 ಇದೆ ಅಲ್ವಾ? 34
ಇದೆ ಸರ್. 34 ಇದೆ
ಮೇಡಮ್. ಎಲ್ಲಿವರೆಗೂ ಆಗಿದೆ ಮೇಡಮ್? ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ನಡೀತಿದೆ
ಮೇಡಮ್? 29 ತಗೊಳ್ತಾರೆ ಇವಾಗ.
ಮೇಡಮ್ ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್ಸ್ ತೋರಿಸ್ತಿಲ್ಲ ಯಾವ್ದು?
ಪಾಸ್ ಏನೂ ಇಲ್ಲ. 29 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
ಸರಿ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ದಯವಿಟ್ಟು ಇದನ್ನ
ಅಲ್ಲಿ ಇಡ್ಬೇಕಾ?
ಇಲ್ಲಿವರೆಗೂ ಬಂದಿಲ್ಲ.
ಅವ್ರು ಅಲ್ಲೇ ಇದ್ರು.
Number 42. ಅದರಲ್ಲಿ interim order until further orders ಇದೆ. 10 days.
Number 29, Sri Ramachandra for the petitioners. Being approached for R1. Geeta Devi NP for R2.
And this is first defendant's appeal, the writ petition law, challenging the order passed by the trial court on 2 IAs
Yes.
on dated 29/9/2016, and against which the appeal was preferred. And in MA, my lord, that the order was passed on 18/4/2017. In MA, the plaintiff filed a cross objections with regard to a dismantle order which was passed by the trial court, that he has not passed, the learned trial judge has not passed with regard to a demolition of the slab. So therefore, that the cross objection was filed, and the cross objection is allowed by the first appellate court and directed to demolish that the slab, including the pillar also, that which was not sought for. The case made out by the plaintiff before the trial court is, it is sued for bare injunction and as well as the mandatory injunction, describing my property, alleging that I have not left any setback and I am putting up construction without by violating the law. And before that the order was being pronounced by the trial court, at the instance of the plaintiff, the court commissioner was also appointed. That court commissioner has given a report stating that as per the bylaw that the plaintiff, the defendant number 1 is required to leave 3.3 feet setback, and he has left more than the 3.3 feet setback in all the corners. The disputed area now is towards eastern side. On the eastern side, the total setback area is left out by the defendant, measuring 5 feet 6 inches. The allegations of the plaintiff, my lord, is that if he puts the staircase and his bedroom is there, so therefore that his right of privacy will be affected. So therefore that he shall not be permitted to put up any staircase for that particular area. And according to him, at one breath he says that he has not left the setback, but in another breath he says that he is not permitted to construct any staircase in the setback. So therefore he is fully aware that the first defendant has left the setback on his side. That even in the commission's report, my lord, and it is pointed out that in the setback area that which is left out by the defendant towards the eastern side, that total 5 feet 6 inches, that to an extent of 4 feet, the total width of the staircase is put up, and still there is 1 feet 6 inches is there for the free air and light. That the allegations of the plaintiff is by putting up such a the staircase, that there is an obstruction for free air and light also.
No, 1 minute.
Please.
On the eastern side where the staircase is put, according to you, 5 feet 6 inches.
It is the setback is left by us.
Setback is left.
Yes, yes.
However, according to plaintiff, in the very same setback, you have put up the staircase construction.
Staircase. But earlier allegation, Lord, is
After the staircase,
Hmm.
towards the eastern side, which is the western side of the defendant
Please.
plaintiff's house,
Please.
is there any setback in your premises?
that there is a 1.6 inches. This still
1.6 inches.
1.6 inches. It is reported in the commission's report also. It is
Yeah,
not
1
that-
feet 6 inches.
6
1.5
inches
feet.
is
Yes.
there. 1.5 feet is still there, my lord. That it will
Ah.
not offset the air and light. So if I put up complete using the entire setback, my lord, then it is a different aspect. That the setback area that what I have left, the commission report has commission has made a report that according to the plan, he is required to leave only this much of the setback, and he has left exceeding that. And at the last, your lordship, kindly I take your lordship to the commission's report is a part of the record. At page 33, my lord, it is annexure G.
Even according to you,
Please, my lord.
what you stated now, and if the commissioner's report is taken into consideration,
Please.
on one side, probably on the eastern side,
Please.
though you claim to have left a
1.6
setback of 5.5 feet 6 inches,
Yes.
but even according to 4 feet width in it has already been used by you in the form of construction of a staircase.
Please, ma.
Staircase.
Yes.
So now the question would be whether a staircase can be put up or constructed in a setback area. If not, then your actual setback would be only 1 feet 6 inches.
Then
If
your
the
lordship,
staircase area is taken as the building area, then the actual setback would be 1 feet 6 inches.
yes, my lord. That
If
your lordship,
according to you, the required setback is 3 feet 3 inches,
please, please.
and what actually left is 1 feet 6 inches,
Please.
then there is a shortage of 1 feet 9 inches width.
Yes, my lord. That your lordship, kindly the last concluding para of the commission's report, my lord.
Yes,
That ಒಂದನೇ ಪ್ರತಿವಾದಿಯವರು ಹಾಜರುಪಡಿಸಿರುವ ಪೇಜ್ ನಂಬರ್ 37
yes, got it.
ಹಾಜರುಪಡಿಸಿರುವ ಸಿಡಿಪಿ ಜೆರಾಕ್ಸ್ ನಕಲಿನ ಪ್ರಕಾರ ಒಂದರೆ ಒಟ್ಟು 1200 ಚದರಡಿ ಕಟ್ಟಡವನ್ನು ಕಟ್ಟುವ ಕಟ್ಟಡದಲ್ಲಿ ಸೆಟ್ ಬ್ಯಾಕ್ ಜಾಗದಲ್ಲಿ ಮೆಟ್ಟಿಲುಗಳನ್ನು ನಿರ್ಮಿಸಲು ಅನೆಕ್ಷರ್ 2 ಟೇಬಲ್ ಸಿ ಪ್ರಕಾರ ಅವಕಾಶವಿರುತ್ತದೆ ಎಂದು ನಮೂದಿಸಿರುತ್ತೆ. That is all matter, lordship may kindly appreciate. These are all the matter requires an evidence. That now at the time of the considering the interim prayer law, because that what is the total extent of the area, that where they total whether it is completely violated, and all these things are to be considered at the time of trial. Because that according to him, my lord, that he has not left any setback, and now he has come up with the contention that in the setback area only he has put up the
No, it is not. His contention is not that, say, there is no contradiction, probably.
No,
There is no contradiction in the contention of the plaintiff. He says, you have not left setback, which means the 3 feet 3 inches totally free, without any obstruction in the form of any structure, is not there. You have put up a staircase in the alleged setback area.
Yes, my lord. But in the-
Therefore, it is as good as, or therefore it is not leaving setback. Setback means it must be totally free.
it is
That is
totally,
what plaintiff's contention is.
if in the event that what we have produced before the commissioner with regard to at the time of inspection, that in the as per the municipal corporations the comprehensive development plan, if the area is very less, that if it is 1,200 square feet, under that circumstances, it is allowable to put up staircase in the setback. Usually in the setback plot, that I also agree. In the setback plot, we are not supposed to put up any permanent structure because it is only to be meant for only for the free air and light. But if the area is very less, so under such circumstances, it is provided that in the setback area also you can put up a staircase. But
Did you canvass that point that say according to CDP, for any site measuring 1,200 square foot or less, in the setback area, staircase can be constructed. Did you canvass this point in the trial court?
Perhaps, my lord, that this particular point might not have been brought to the notice of the trial court or the first appellate court. But the commission, before the commissioner, it was brought to the notice. Based on the
It
commission.
is exactly, Mr. Counsel, I am asking.
Exactly. It is.
Even before the matter could be argued,
Yes,
before the trial court and the lower appellate court,
the commissioner.
you had known that fact and you had brought the same to the notice of the commissioner.
Yes, ma'am.
When you have brought this aspect to the notice of a commissioner, what prevented you from bringing the same to the notice of the court?
But we did not brought to, but the commission report is a part of the record also, Milad. That I cannot say because the counterpart have made a submission before the court that it is not narrated in the, or it is not observed by
It is
the.
not for the commissioner to say
No,
what
I
is
am
the
not saying-
CDP, what
No.
are the exemptions in CDP.
No.
That is not probably that
Yes,
was
sir.
not the instruction given to the commissioner to submit his opinion or report.
No, madam, it is.
He was appointed for a local inspection to
Yes.
ascertain the position. What is the plinth area? What is the site area? What is the construction area? What is the setback? If
He
left,
has
and what is the alleged encroachment of the setback? That is all.
He
The
has given.
position of law, the appreciation of the other documents, if any,
Yes, sir.
were none of the business of the commissioner.
It
Number
is-
one. Number two, commissioner also has not stated that according to CDP, the defendant number one is entitled to put up staircase. That is not the finding or the report of the commissioner.
No, he,
Commissioner has only placed on record what was submitted to him. He said defendant number one submits.
yes, exactly right.
Such a
I am not-
provision is there, and in CDP
No,
it is shown so.
I am not pointing out any mistake in the report submitted by a court commissioner. I am
Yes.
only pointing out and making my submission before the honorable court is
Yes.
that before the commissioner, that when it was inspected, he has
Hmm.
not stated that, my lord, that the first defendant or the petitioner has not put up a staircase in the setback
Not
area.
necessary.
It is, no, it is not the report of the commissioner. He has said that he has constructed to an extent of 4 feet width. He did not say that according to this, therefore he is permitted. It is not the opinion of the commissioner also, that he cannot give such an opinion before while writing the report also.
Which one?
In so far as which I have brought to your lordship notice now, the last paragraph, that it is not his opinion, as your lordship is expressed that, Lord, it is not
That
his
is with respect to CDP.
CDP. It is only in respect to the CDP that under such circumstances, when the area is to that particular extent, under such circumstances, even though the staircases have been put up in a setback area, they are permissible. That I am not saying that I have not put up any construction, but it is in the report, and even it is notified that out of the total extent of 5 feet 6 inches, then the 4 feet width is the staircase is put up. It is reported by the commissioner also He has
Yes.
it is not stated that commissioner has yeah, only by relying on the CDP report what I have placed before him, and he has no under these circumstances he has permitted. It is not the report submitted by the court commissioner. Court commissioner has given the exact position. What are all the constructions and what are all the building has been come up. Send what is the entire measurement he has given. That I am not saying that the commissioner before commissioner, but of course, as your lordship has put me a question, that my counterpart has brought to the notice of the honorable court with regard to the CDP where the area is very limited. Under such circumstances, can we permitted to put up such a staircase in the setback area, and it has not been observed by the trial court or by the first appellate court.
What is your point of argument then?
Point
What
of-
error you find in the impugn
Lord is,
order?
he says that by putting up such a staircase, that
Huh.
his right of privacy will be affected.
Yes.
So for that, my lord, that putting up such staircase, that
Huh.
as contended by them, because
Huh.
he has purchased a constructed building. He has not bought the purchased the vacant site and thereafter he has constructed, because much prior to the property which I am purchasing, that by the time that the property was already, the house was already constructed, and he purchased a constructed house.
Mr. Counsel, it was only the cellar portion that was constructed.
No, it is not.
The first floor was not fully constructed.
No,
First floor construction was put up by you.
not for me, my lord, that I am making submission with regard to the building purchased by the plaintiff.
Huh.
Plaintiff, my submission, my lord, is not with regard to my property.
Huh.
My property which I am taken up a construction.
No, when did the plaintiff purchase the building? Before prior to your
Yes, yes.
construction or subsequent to your construction?
No, prior to construction.
Prior to your construction.
Because he has already, he purchased the constructed building.
Huh.
He has not purchased the vacant site and thereafter constructed, but he purchased the constructed building itself. So
Yes, what difference does it make?
no, that my submission, my response submission to Lordship is, he says by virtue of putting these staircase, that his movements will obstruct his right of privacy because his bedrooms are situated on that particular point. So for that, my lord, even though I have put up a construction of the staircase and other things, in order to avoid such a affecting the right of privacy, that the seats are already put on that particular area, that it will not obstruct the right of privacy of the defendant also, plaintiff also. So if I kept the staircase open, my lord, then it is the contention of the plaintiff is absolutely all right, that it affects his right of privacy. That I have closed. I put a sheet.
Closed in what sense?
That close in the open area where I have put up the staircase, my lord. That particular area where his bedrooms and his property is being situated. That for that area, my lord, that I have completely closed.
That means you have further violated his personal rights.
It is not a violation, my lord.
Exactly.
It is only with regard
you have further violated his
No,
personal
it is
rights for free air and light.
air and light, my lord, that 1.5 feet.
How
is
can you erect the plastic sheets there?
1.5 feet.
4 feet means 3.3 feet. If the law mandates means 3.3 feet, it must be clear, open.
That
'Unobstructed flow of air and light must be there.'
1.6 feet is already there, my lord.
Yes.
It will not obstruct.
Add to that 1.9 inches. For 1.9 inches, demolish the staircase, or alternate. Ultimately, it is an interim order, subject to what you submit. Ultimately, it is an interim order.
Please,
For remaining 1.9 feet, you put up certain blocks to the satisfaction of the plaintiff in such a manner and such a fashion that you cannot step on those blocks. That means you cannot make use of 1.96 feet as a staircase throughout. Remaining portion, you can make use of, so that erecting or putting up any plastic sheets or any other shield to cover their bedroom windows or any other
please.
flow of light and air, that obstruction would not be there. In the meantime, it will be as good as leaving 3.3 feet open passage. Tomorrow, if you succeed, remove our obstructions. If he succeeds,
Then I will,
demolish that 1.9
I will
inches,
advise my client to that.
limiting the staircase. ಹಾಗೆ
I will-
ಮಾಡ್ಬೋದಲ್ಲ?
I will advise to.
ಅವಾಗ ಸ್ಟೇರ್ ಕೇಸ್ ಈಗ 1 ನಿಮಿಷ, ಸ್ಟೇರ್ ಕೇಸ್ 4 ಕಡೆ ಆಗಲ ಏನ್ ಕಟ್ಟಿದ್ದಾರೆ, ಪೂರ್ತಿ ಸ್ಟೇರ್ ಕೇಸ್ ಈಗ ಹೊಡೆಯುವ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಇದು ಇಂಟರಿಮ್ ಆರ್ಡರ್. ಅದಕ್ಕೇನು ಎವಿಡೆನ್ಸ್ CDP ಎಲ್ಲದೂ ಬರ್ಬೇಕು. ಆದ್ರೆ 1 ಅಡಿ 6 ಇಂಚು ಅವರು ಅವರ ಸೈಟಿನ ಈಸ್ಟ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಈಸ್ಟ್ ಸೈಡ್, ನಿಮ್ಮದು ವೆಸ್ಟ್ ಸೈಡ್ ಬಿಟ್ಟಿದ್ದಾರೆ. ಇನ್ನೂರು ಬಾಕಿ ಬಿಡಬೇಕಾಗಿರೋದು 1 feet 9 inches. ಆ 1 feet 9 inches ಸ್ಟೇರ್ ಕೇಸ್ ಏನಿದೆ, ಆ 1 feet 9 inches ಸ್ಟೇರ್ ಕೇಸ್ ಮೇಲೆ ಸಿಮೆಂಟ್ ಬ್ರಿಕ್ಗಳನ್ನ ನಿಲ್ಲಿಸಿ ಅದಕ್ಕೆ ಸಿಮೆಂಟ್ ಹಾಕ್ತಾರೆ ನಿಮ್ಮ ಸಮಕ್ಷಮ. ಅವಾಗ ಆ ಪೋರ್ಷನ್ ಅನ್ನ ಅವ್ರು ಸ್ಟೇರ್ ಕೇಸ್ ಆಗಿ ಯೂಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಮ್ಯಾಕ್ಸಿಮಮ್ ಅಂತ ಹೇಳಿದ್ರೆ ಸಿಮೆಂಟ್ ನ ಬ್ರಿಕ್ ಇಟ್ಟಿರೋದ್ರ ಮೇಲೆ ಒಂದು ತಟ್ಟೆಯಲ್ಲಿ ಸಂಡಿಗೆ ಮೆಣಸೋ ಸಂಡಿಗೆನೋ ಒಣಗ್ಲಿಕ್ಕೆ ಇಡಬಹುದು. ಅಥವಾ ಏನಾದ್ರು ಮನೆ ಉದ್ದಿನ ಬೇಳೆ ಕಡಲೆ ಬೇಳೆ ಇರುವೆ ಬಂದಿದ್ರೆ ಕುಟ್ಟೆ ಬಂದಿದ್ರೆ ಅದನ್ನ ಬಿಸಿಲಿಗೆ ಇಡಬಹುದು ಅಷ್ಟೇ. ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಉಪಯೋಗಿಸ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ನಾಳೆ ನೀವು ಸಕ್ಸೀಡ್ ಆದ್ರೆ ಆ 1 feet 9 inches ಪೋರ್ಷನ್ ಸ್ಟೇರ್ ಕೇಸ್ ಅವ್ರು ಡಿಮಾಲಿಷ್ ಮಾಡ್ತಾರೆ. ಅವ್ರು ಸಕ್ಸೀಡ್ ಆದ್ರು ಅಂದ್ರೆ ಅಲ್ಲಿ ಏನು ಅವ್ರು ಅಬ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಟ್ಟಿದ್ದಾರೆ ಅಥವಾ ಇಡಬೇಕು ಅನ್ನೋ ಒಂದು ಸಜೆಷನ್ ಇದೆ, ಆ ಅಬ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಟ್ಟ ಪಕ್ಷದಲ್ಲಿ ಆ ಅಬ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತೆಗಿತಾರೆ. ಹಾಗೆ ಮಾಡಿ ಅವಾಗ ನಿಮ್ಮ ಬಿಲ್ಡಿಂಗ್ ಉಳಿಯುತ್ತೆ,
Please.
ಏನು ಮಾಡದೆ ಇರೋ ಹಾಗೆ. ಇದು ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಹೀಗೆ ಇರ್ತದೆ. ಬಟ್ ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ವಿತ್ ದಿ ಕನ್ಸೆಂಟ್ ಫ್ರಮ್ ಬೋತ್ ಸೈಡ್ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಮಾಡಿಫೈಡ್ ಟು ದಟ್ ಎಕ್ಸ್ಟೆಂಟ್. ಡಿಮಾಲಿಷನ್ ಪದ ತೆಗೆದು ಡಿಮಾಲಿಷನ್ ಅಲ್ಲಿ ಪುಟಿಂಗ್ ಅಪ್ ದಿ obstructions in such a way to the
Please.
satisfaction of the plaintiff, preferably by putting the hollow large cement blocks covering 1.1 feet 9 inches area in the staircase in the east-west direction, so that the total common area would be enlarged on temporary basis to 3 feet 3 inches.
That I will advise to that extent to my client. There is no difficulty about it.
ಹಾಗೆ ಕೇಳಿ ಹೇಳಿಕ್ಕೆ ಏನಾರು ಇದೆಯಾ ಅಥವಾ ಹಾಗೆ ಆರ್ಡರ್ ಮಾಡಬಹುದಾ?
ಕೇಳಿ ಹೇಳ್ಬಿಡ್ತೀನಿ. You will ask me kindly call this matter on Monday. By that I will advise my client and.
ನಾನು ಇದನ್ನ ಕೇಳದೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ
ಇಲ್ಲ, ಇಲ್ಲ.
ಹೋಗ್ತಿದ್ರಿ. ನಾನು ಮತ್ತೆ ಕೇಳಿ ಹೇಳ್ತೀರಾ ಅಂತ ಹೇಳಿದ ಕೂಡಲೇ ನಿಮಗೆ ಸಿಕ್ಕಿದೆ ಚಾನ್ಸ್ ಹೋಗ್ತೀರಿ
ಅಲ್ಲ
ಅಲ್ವಾ ಕುಂಬಾರ್ರೆ?
ಅಲ್ಲ, ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಇಟ್ ಇಸ್ ಅನ್ ಆರ್ಡರ್. At least we expect that not if lordship not.
ನೀವು ಕೇಳಿ ಹೇಳಿದ್ರೆ ನಾನು ಕನ್ಸೆಂಟ್ ಅಂತ ಬರ್ಕೊಳ್ಬೇಕಾಗ್ತದೆ, ಇಲ್ಲದೆ ಹೋದ್ರೆ ಆರ್ಡರ್
Okay.
ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
So it avoid
ಎಫೆಕ್ಟ್ ಒಂದೇ,
avoid
ಅದರದ್ದು ಪರಿಣಾಮ ಒಂದೇ ಇರುತ್ತೆ.
the effect is what.
ಕನ್ಸೆಂಟ್ ಅಂತ ಬರ್ಕೊಂಡ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಇಬ್ರಲ್ಲಿ ಯಾರು ಹೋಗ್ಲಿಕ್ಕಾಗಲ್ಲ, ಅಪೀಲ್ ಯಾರು ಹೋಗ್ಲಿಕ್ಕಾಗಲ್ಲ.
So we can go and face
ಡೈರೆಕ್ಷನ್
it.
ಅಂತ ಆದ್ರೆ ಹೋಗ್ಬಹುದು.
Aye, sir. We can face
ಹಾಗೇನಾದ್ರೂ
it
ಹೋದ
well.
ಪಕ್ಷದಲ್ಲಿ ಹೀಗೂ ಆರ್ಡರ್ ಮಾಡಬಹುದೇ ಅಂತ ಒಂದು ಹೊಸ ನಮೂನೆಯ ವಿಧಾನ ಕಂಡು ಬರುತ್ತೆ. ಸಂತೋಷ. Learned counsel for the petitioner is appearing through video conference. Learned counsel for the respondent 1 is appearing physically. learned counsel for respondent number 2 neither present physically nor through video conference. After making some submission from both sides, the outcome between the learned counsels was that since the impugned order oblique judgment is only an interim relief to the plaintiff in the original suit, the defendant can consider the defendant number 1 can consider of not using 1 feet 9 inches of the entire staircase area towards the property of the plaintiff and putting up some temporary obstructions for the said width of 1 feet 9 inches throughout the staircase on all the alleged 11 steps. 11 ತಾನೇ ಮೆಟ್ಲಿರೋದಲ್ಲಿ
ಹನ್ನೊಂದು
ನೋಡಿ, ನಾ ಮೆಟ್ಲನ್ನು ಎಣಿಸಿ ಬಂದಿದ್ದೇನೆ, ನೀವು ಬರೀ ಕೇಸ್ ಪೇಪರ್ ನೋಡಿದಿರಿ. ಎಂತ ಒಂದು 11 steps, so that 11 steps like fixing the large size hollow cement blocks on those steps, so that in case if the plaintiff could not succeed in the suit, those hollow cement blocks can be removed, and in case if plaintiff succeeds, the shortening of the total width of the staircase permanently by a measurement of 1 feet 9 inches in its width can be effected. In that regard, learned counsel from both sides submit that they would, in that regard, accordingly, the impugned order be modified. In this regard, learned counsel from both sides pray for a short accommodation to discuss with their clients and to make their submission in this regard. Mele leaving 1 feet 9 inches, 1 feet 9 inches width anta bantala, al bracket alli to make the total setback area at 1 feet 9 inches plus 1 feet 6 inches, small bracket already in existence. Close the small bracket, equals 3 feet 3 inches. Close the big bracket. Last one. List this matter ಯಾವತ್ತಾಗಬಹುದು? ತಮಗೆ ಯಾವಾಗ ಆಗಬಹುದು?
ಮಂಡೇ ಆದ್ರೂ ನನಗೆ ಐ ವಿಲ್ ಕನ್ಸಲ್ಟ್.
43
ಪ್ಲೀಸ್.
Cinema 30 is adjourned. Cinema 31, Sri Sanat Kumar Shetty K for the petitioner, Joshua Samuel for the respondent.
ಬೆಳಗ್ಗೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ interim order granted earlier is extended by 10 days from today.
Sri Dwarkanath HS for the petitioner, Hareshar for the respondent.
Petitioner, my lord.
Yes.
But the petitioner is a plaintiff in a suit for permanent injunction and declaration of easementary rights, my lords. Easementary rights sought is that
The petitioner is?
a plaintiff, my lord.
Hmm.
In the suit for permanent injunction and declaration of easementary rights.
Hmm.
Alternately. Now, the easementary rights which is sought is that the petitioners have to approach their property, my lords, which is Schedule A property, only through the road, which is on Sarkari Sarkari Hallan, which is the Schedule B property. What has happened? They have been using this road as it is the only way of approach to their property, my lords. What happened? These defendants, my lords, have been obstructing the movement and approach for the plaintiffs and their family members by destruction of the electric poles, and road they obstructed. And hence we filed a suit for permanent injunction and declaration of the easementary. Plus, the defendants have filed a written statement and they have denied that this is the only way of our approach. And they've also made a statement saying that road.
Your approach to your lands,
My land.
agricultural land.
My land, please. Ma'am. So their contention is that particular road, which is on Sarkari Hala, adu namdu anta helta. And then they say, my lord, they say this suit is not maintainable because we have sought only for injunction and not sought for declaration. Really, that is their contention, and they deny that this is the only approach that we have. Having said in that, my lords, issues have been framed at annexure D, my lords. Lordship would kindly see, there has been a specific assertion by the plaintiffs with respect to the easementary rights, and there has been a specific denial by the defendants. Yet, the Lordship would kindly see, there is no issue with respect to easementary rights. The Lordship would kindly see at annexure D, my lords, at page 25. Hence, the plaintiff has filed an application under Order 14, Rule 5, which is at annexure E, my lords, seeking for, firstly, that the issue number 3 has to be recasted. Secondly, for an additional issue. I may take your lordships.
One moment.
If I can draw your lordship's attention to the application that we have formed, we have applied, we have filed, which is at annexure E, page 26. We are seeking for recasting of issue number 3 minutes. Issue 3 in Helatandre, whether the defendant proves that the suit is not maintainable without seeking declaration. My lords, this is totally incorrect. In as much as we have specifically and explicitly mentioned in our plaint, in the prayer, if I could draw your lordship's attention to page 16 of the plaint minutes.
Have you produced the written statement?
Please, my lord. It's at
Where?
Annexure C, page 21. ma'am. Seven, they deny that there is any other approach.
Page?
My lords, at page 18, my lords, annexure C. And further at page 21, my lords.
W. Written statement, paragraph number
21. Sorry, 14, para 14, page 20.
yes.
Ali, they make a mention, my lord, the allegations in para 13 that except through Schedule B property, plaintiff has no right of way is totally false, and plaintiff has put to strict proof of the same. When the plaintiff sought for easementary rights without seeking declaratory relief, the suit for mere permanent injunction is not maintainable. And our health. But if your lordship would kindly see at page 16 of the prayer of the plaintiff, my lords.
One moment.
Page 16. The first paragraph B, my lords, it's the prayer, continuation of the prayer. And alternatively, B, and alternatively for declaration that the plaintiff has easementary rights of way. And thus specifically there is a prayer, my lords. And thus that issue number 3 has to be recasted as there is a lucidly we have mentioned, we have sought for the prayer.
How you are affected with the existing issue?
The present third issue, my lords.
Yes.
Because it is totally incorrect, my lords. It is not whether the suit is not maintainable without seeking declaration. I have specifically asked for declaration, my lords. So it has to be recasted as my submission to your lordship. Clear a prayer al haki declaration. So that cannot be an issue is my respectful submission to your lordship.
What is the impugned order here?
My lords, at page 8, my lords, annexure A, the impugned order mentions that there are no specific pleadings. Before that, I would like to draw your lordship's attention with respect to the pleadings in the plaint and the assertion in the written statement.
One moment. How do you overcome the finding of the trial court that say without even mentioning what type of easement you have, right of easement you have, you cannot seek any framing of the issue in that regard?
Yes, my lords, in that regard, I have a good citation which says how, my lord, the pleadings, however, should receive a liberal construction, no pedantic approach, should be adopted to defeat the justice on hair-splitting technicalities. Sometimes pleadings are expressed in words which may not expressly make out a case in accordance with strict interpretation of law. In such cases, it is the duty of the court to ascertain the substance of the pleadings to determine the question. It is not desirable to place undue emphasis on form. Instead, the substance of pleading should be considered. Whenever the question about lack of pleading is raised, the inquiry should not be so much about the form of pleadings. Instead, the court must find out whether the substance of the parties knew the case or so on. Can I be permitted to submit this?
That's good.
Relevant portion is marked.
That is all.
Further, it also reads, my lord, that the object and the purpose of pleading is to enable the adverse party to know the case it has to meet. In order to have a fair trial, it is imperative that the party should state the essential material facts so that the other party may not be taken by surprise. Further, my lord, having said and done at para 5 in the plaint and para 9 of our plaint, there has been specific assertion with respect to our rights, my lord, a right of way. And accordingly, there has been a specific denial by the defendants at paragraph 7 of the return statement, my lords. So, in accordance with order 14, rule 1(3), my lords, when there is, if I may be permitted to read out to your lordship, issues arise, framing of issues. Each material proposition by one party and denied by the other shall form the subject matter of a distinct issue. Having said and done, my lords, when there is a specific assertion and a denial, I pray that this honorable court would permit the
Counsel for the petitioner alone is present. The counsel for respondent neither present physically nor through video conference. For the submission of the counsel for the petition. Place the matter on 15.
think, my lord.
11.3. The interim order granted earlier is extended till then.
Much obliged.
Silver 33, Sri Sagar, BB for the petitioner, Sri S.C. Vijay Kumar for the respondent.
Yes.
Look, the present writ petition minutes, the order include minutes arises out of the proceedings minutes and execution petition number 25 2016. Look, the execution petition minutes itself is dismissed for non-prosecution. As such minutes, the present writ petition minutes do not avail for execution. That effect minutes on filing.
If you have no objection.
The execution petition is restored to its original file minutes, I may be permitted to revive the writ.
You cannot keep it in coma.
No minutes.
For your latches, they're getting the execution petition dismissed.
No minutes. In the before the executing court minutes and the judgment data, the respondent minutes is the decree holder. Minutes challenging an order minutes of issuing notice minutes as to why the judgment data should not be arrested. Minutes against that order minutes, this writ petition was filed. Now minutes, the execution petition minutes that is preferred by the respondent minutes is dismissed for non-prosecution.
Non-prosecution.
Yes, ma'am. Now in the event minutes, the execution petition minutes is revived. Minutes, then minutes, my writ petition minutes would require consideration. Minutes. As of now, minutes, since the execution petition stands dismissed.
No, say we will hold that in case the execution petition is revived, you are at liberty to file a fresh writ petition on the same cause of action, so that you can improve your pleading. Otherwise, for 10 years, if it does not file recalling application, do you mean to say that for 10 years we should keep this writ petition papers aside?
I'll file it.
Yeah.
Only on the account of.
So, make that necessary correction. That underlined portion also is required to be removed. Put your initial. Show the memo to other side, obtain their signature. There are counsel from both sides present. There are counsel for the petitioner files a memo stating that in view of the fact that the execution petition from which the present petition has arisen, has now stands closed at the default of the decree holder, the present petition becomes infructuous. However, the petitioner has sought reserving his liberty. However, the petitioner has reserved his liberty to file fresh writ petition in case the said execution petition is restored in the court. Learned counsel for the petitioner makes similar submission in his oral submission. The learned counsel for the respondent, after going through the memo, submits his no objection to consider the memo. In view of the memo and supporting submission, reserving liberty to the petitioner to file a fresh writ petition in case the alleged execution petition number 25/2016, which is said to have been closed by the orders of the District and Sessions Court of Chitradurga, is revived. It will read a sentence.
Is the alleged execution number so and so said, which is said to have been closed by the orders of the District and Sessions Judges Court Chitradurga, is revived.
Revived, the present writ petition stands disposed of.
Number 34, Sri P. N. Harish for the petitioner, Sri S. V. Prakash for the respondent.
I am for the respondent, my lord.
Disposed of as having become infructuous.
state this is setback after execution. You are the judgment data. Is it an undisputed fact that a compromise was entered into between the parties?
That as far as the pleading is concerned, there is no dispute. Because what are the terms of the compromise, it is not known. It is decreed as per the terms of the compromise petition. That only I could admit, because the terms of compromise is nowhere disclosed. Even the petitioner also contains that she is not aware of the terms of the contract, that is the compromise.
You filed the execution petition without the decree attached to it?
Yes, madam. Since it has been given endorsement that all the records have been destroyed, madam.
No. Don't show the finger towards the court. Compromise decree was passed in the year 2007, right?
Yes, madam. Yes, madam.
You filed execution petition in the year 2014, right?
Yes, madam.
So for 7 years, what you are doing, which prevented you from obtaining a certified copy of the decree?
No, it is
You answer that first. Don't simply say, no, by the time I say approach, the records were already destroyed.
My lord, may I make a suggestion? Actually, those records cannot be destroyed, my lord.
Exactly.
Cannot be destroyed. But how the court has issued, I don't know. I am a litigant, my lord.
Mr. Counsel, try to understand.
Yes, my lord.
The judgments and the decree cannot be destroyed, fine.
Yes, my lord.
The rules of
how?
practice says the court has destroyed it.
Yes.
Did you question the court
No.
in a
My
manner
party.
known to law
My
as to
party.
how come it destroyed the records? You have got a right to apply for certified copy, maybe even after 10 years.
Yes, my lord. Yes,
Now, did you question that?
my party has not questioned it, my lord, before
Yes,
the
you
trial
should have
court.
done that first.
But alternatively, he obtained the register was available. That extract of the register has been obtained.
No,
and,
whether the
produced,
extract
my
of
lord.
the register speaks about the terms of compromise.
No.
Then what is the use?
No, but it shows, it reflects that what was my claim.
Mr. Counsel, you tell me in one sentence, what is that you want to execute?
Decree.
Decree. What
Yes.
the decree says?
But my lord, it is not in my custody, my lord.
No, what the
The
decree
litigant,
says.
you know, my lord, litigant cannot be blamed, my lord. Litigant cannot be blamed. It is in the custody of the court. It is the custodian of the documents. Whenever I applied for it, it is the duty of the
No. One thing.
record keeper to
Let me
furnish the
clarify.
document, my lord.
You
No.
please clarify about the procedure.
If it is in my custody, I can be blamed, my lord.
No,
My-
one
my
second,
lord.
Mr. Counsel.
My
You
submission is
clarify
that.
me. A decree holder who files execution petition, is he not expected to file a certified copy of the decree along with the execution petition?
My lord,
If answer is yes,
decree
then
holder
you
has,
should tell me why you did not file.
my lord,
If the answer is no, you should draw my attention to the provision of the law or rule or circular.
my,
I will say that.
yes,
If you are not supposed to file certified copy of the decree, fine, tell me that,
may I make a submission?
please.
My lord, my party, why he has not applied immediately, I was not aware. It is at his wisdom and his legal assistance, what suggested, I don't know, before the trial court. But when he wanted to file execution, since as per the terms of the compromise, the judgment debtor not paid the money. It was sheer violation of the compromise decree. Thus, he wanted to file execution. For that reason, he applied for the certified copy of the decree. Then it was told to him by issuing announcement, all the records have been destroyed. How it was destroyed, I don't know. And it was not challenged by the party. And the
ನೀವು ನಿಮ್ಮ ಕೆಲಸ ಸುಲಭ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಏನೋ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ
ಇಲ್ಲ
ಇದ್ದೀರಿ.
ಸರ್, ವಾಟ್
ನೀವು ಓದ್ಬೇಕಾದಷ್ಟು
No, my
ಓದ್ತಾ
lord.
ಇಲ್ಲ ಅಥವಾ ಓದಿ ಕೋರ್ಟಿಗೆ ಅಸಿಸ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಇಲ್ಲ. My lord,
ನೀವು ಏನ್ ಫ್ಯಾಕ್ಟ್ ಕೆಳಗಡೆ
Seal rules of
ಏನ್
practice.
ಹೇಳಿದಾರೆ ಅದಕ್ಕೆ ನೀವೇನ್ ಸೇರಿಸಬಹುದು ಸೇರಿಸಿ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ನನ್ನ
ಇಲ್ಲ.
ಪ್ರಶ್ನೆ ಅದಲ್ಲ. ನನ್ನ ಪ್ರಶ್ನೆ ಇರೋದು
Your
ಮೊದಲನೇದಾಗಿ
lordship is right, my
ಮೊದಲನೇದಾಗಿ
lord. Without applying
a
for
court which
decree.
passes a judgment, it cannot destroy the judgment. Pleadings, judgment and the decree are permanent record. You
Yes,
draw
my
my
lord.
attention to that.
It is there, my lord.
Civil rules of practice ತೆಗೆದು ನೋಡ್ರಿ ಇದೆ ಇದರಲ್ಲಿ. ನನಗೆ ಓದಿ ಹೇಳಿ.
Rule 202, my lord. File
ತೆಗೀರಿ,
A
rule
shall be
202.
preserved permanently. Rule 202, my lord. File A shall be preserved permanently. File B shall be destroyed at the end of the 6 years. File C shall be destroyed at the end of 3 years, provided the documents and records produced in courts by government officials are sent for under Rule 10 of Order 13 of the code shall not be destroyed.
Judgment and decree forms part of file A, right?
Yes, my lord. For that reason only, my lord. For that reason only, it is in the custody of the court, my lord. How it has been destroyed, I don't know. When such endorsement has been issued.
ಅಲ್ಲಿಗೆ ಬರುವ ಹಂತ ಹಂತವಾಗಿ ಹೋಗುವ.
Yes,
ಒಂದೇ ಸರ್ತಿ ಅದು ಏನು ಅಂತ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರೆ ಇಲ್ಲಿ ಆರ್ಡರ್ ಬರೀಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಇಲ್ಲ ಆರ್ಡರ್ ಬರೀಬೇಕಾದ್ರೆ ನಮಗೆ ನಿಮ್ಮಿಂದ ಹಲವಾರು ಇನ್ಪುಟ್ ಬೇಕು, ಅವರಿಂದ ಹಲವಾರು ಇನ್ಪುಟ್ ಬೇಕು.
Yes.
ನೀವ್ ಹೇಳಿದಷ್ಟು ಸುಲಭದಲ್ಲಿ ನಾನು ಬರದೆ ಅಂದ್ರೆ ಅದು ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ ಆಗುತ್ತೆ.
I understand.
ಅಷ್ಟು ಸುಲಭದಲ್ಲಿ ಇಲ್ಲಿ ಬರಿಬೇಕಂತ ಹೇಳಿದ್ರೆ ನಿಮ್ಮಿಬ್ರಲ್ಲಿ ಯಾರು ಒಬ್ರು ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ರೆಡಿ ಆಗ್ಬೇಕು.
ವಸೂಲ್ ಮಾಡ್ಕೊಳ್ಳೋದೇ ಕಷ್ಟ ಆಗಿದೆ.
Yes.
Did you apply for certified copy before filing execution petition? Now, the question number 2. Whether an execution petition
Yes,
is required to be accompanied with certified copy of a decree.
yes, my lord. On 5/6/2014, the copy is available, my lord. It was applied to the court, my lord, in second additional civil judge Shimoga. Pray for issue of the certificate copy of the registered number 1 extract, register number 1. Sorry, my lord. Sorry.
Yes, when the JDR disputes the very alleged amount claimed in the execution petition, stating that there is no decree copy as such, JDR is not aware the terms of the compromise. How you execute the alleged compromise decree?
May I make a submission, my lord?
Please.
My lord, earlier, your lordship has put a question. When did you apply for the certificate copy? That information is not available with me. Another 1 week time may be granted. I will get the information and also documents, entire documents from the executing court lawyer. My lord. By that, I may be able to answer your lordship.
ನಿಮ್ಮ ಹತ್ರ ಇದ್ರೆ ಕೊಡ್ರಿ.
ಇಲ್ಲ ಸುಮ್ಮನೆ ಡಿಗ್ರಿನೇ ಇಲ್ಲ. Actually, what has happened is that is there are some fishy that has happened, as could be seen from it. Because 2007 ಅಲ್ಲಿ ಡಿಗ್ರಿ ಆಗಿರೋದು 2014 ತನಕ ಅವ್ರು ಸುಮ್ಮನೆ ಇಟ್ಕೊಳ್ಳೋಕೆ ಚಾನ್ಸ್. ನಂಬರ್ 1, all practical purposes. Then we will kindly see within 1 month no court would get destroy the file A. It is obligatory on the part of the court to keep the record permanently. File A nanda is one of my grounds also. So there are kindly see register 2 to copy happen. Register is 2 for small causes, not for civil original suits. Where the report portaralla register 2, it is for small causes. So small cause portal in our whole also I don't. That is also one of my grounds in the petition. Annexure affection that is register 2 they have produced. My page number 18, annexure C, the type copy is page number 19.
The compromise, Ali's compromise was entered into in which court?
That is also not known, my lord. That is also not known. That is the reason. At LDC, the suit is according to the decree holder is for 1,40,000 with 18% interest. According to them, it is compromised for full.
Only 40,000 under the Yava court birthday, city civil court.
The principal
Civil judge court.
Junior division.
Junior division.
Time of the decree holder is, it is as whatever he has claimed, it has been agreed to be paid.
ನಿಮ್ಮ ಸ್ಯಾಲರಿ ಅಟ್ಯಾಚ್ ಆಯ್ತಾ? ಅವಾಗ ನೀವು ಸುಮ್ಮನೆ ಇದ್ರಿ.
Salary attachment ಆಗಿ ಪ್ರಪೋಸಲ್ ಹೋದ್ಮೇಲೆ then we verified it and filed objection. 2015 ಅಲ್ಲಿ ನಾನು ನೋಟಿಸ್ ಮಾಡಿದೆ.
ನೋಟಿಸ್ ಬರ್ಲಿಕ್ಕೆ ಮುಂಚೆನೇ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆಗಿತ್ತಾ?
ಇಲ್ಲ, ನೋಟಿಸ್ ಬಂದ್ಮೇಲೆ ಆಗಿದೆ.
ಬಂದ್ರ ಮೇಲೆ ಆಗಿದೆ. ಸ್ಯಾಲರಿ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಮುಂಚೆ ದಿ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಹರ್ಡ್ ಯು. It's only after hearing you the attachment of salary would be generally ordered.
That is also one of my contention. Kindly see in my statement of objection filed to the execution. Page number 17. Page number 17. Last paragraph. It is submitted. May I just read, madam? I have taken specifically page number 17. It is submitted matter compromise to justice of the execution filed in year 2014 and assessed the warrant issued for attachment of salary of JDR. So issuing the cause notice is also illegal and opposed to law. So before issuing the cause notice, salary attachment was ordered. Destroying of the decree is concerned, my lord. It is not their case that at the time of filing the execution, they have annexed that. It is only subsequent to my application, in their objection statement, they take such contention.
So what your client is doing? Teacher. Working as a teacher. ಎಲ್ಲಿ ಹೇಳಿ
ಮೇಂಟೆನೆನ್ಸ್ ಆಫ್ ರೆಕಾರ್ಡ್ಸ್ ಇನ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ರೂಲ್ 180 ಮತ್ತು 181 ಅಲ್ಲಿ ಎ ಫೈಲ್ ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ. 182 ಮತ್ತು 183 ಅಲ್ಲಿ ಬಿ ಮತ್ತು ಸಿ ಫೈಲ್ ಬಗ್ಗೆ.
Ultimately, when you yourself have admitted that some compromise was entered into between the parties.
That back I have, but my legally in law, when unless and until the decree holder satisfied what is the agreed amount by filing at least a compromise certificate copy of the compromise petition. Can the JDR would be held liable to say that this is the amount you are
ಅಲ್ಲ ಅದಕ್ಕೆ ಆಮೇಲೆ ಬರುವ. ಈಗ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ ಅಂತ ಇಬ್ರು ಒಪ್ಪಿದ್ದೀರಿ. Both of you have agreed that a compromise was entered into between the party. According to the decree holder, he has no paper with respect to the compromise. At least a compromise petition copy. ನಿಮ್ಮ ಹತ್ರ compromise petition copy ಇದೆಯೇನ್ರಿ?
ಇಲ್ಲ.
ಇಲ್ಲ. Compromise petition copy ಇಲ್ಲ. ಡಿಕ್ರಿ ಇಲ್ಲ. ಆಮೇಲೆ ಸ್ಯಾಲರಿ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಗೆ ಮುಂಚೆ ಅವರೇನಾದ್ರೂ ಮೆಮೋ ಹಾಕಿದ್ರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಷ್ಟು ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ, ಇಷ್ಟು ಟರ್ಮ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನೋದು ಇಲ್ಲ. ಹಾಗಿರೋ ಸಂದರ್ಭದಲ್ಲಿ ಈಗ ಪ್ರೂಫ್ ಏನಿದೆ, ಎವಿಡೆನ್ಸ್ ಏನಿದೆ, ಡಾಕ್ಯುಮೆಂಟ್ ಏನಿದೆ ಅನ್ನೋದಕ್ಕಿಂತಲೂ ಮುಖ್ಯವಾಗಿ ಇಬ್ಬರು ಪಾರ್ಟಿಗಳ ಮಂಜುನಾಥ ಶಾಂತಕುಮಾರಿ ಅವರ ಆತ್ಮ, ಅವರ ಕಾನ್ಶಿಯಸ್ ಏನ್ ಹೇಳುತ್ತೆ ಅವರಿಬ್ಬರಿಗೆ ಗೊತ್ತಿದೆ. ಒಬ್ಬಾಕೆ ಟೀಚರು ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ ಅಂದ್ರ ಮೇಲೆ ಅದರಲ್ಲೂ ಆಕೆ particularly when she was the defendant in the original suit and the compromise has entered into, it can be presumed, I am not telling it is a fact, it can be presumed that being the defendant she has agreed for a compromise means she has agreed to pay some amount.
That is what some amount.
Some amount. What that amount, it is only both those parties knows. Leave the decree holder, that is the plaintiff, aside for a minute. Let your client introspect herself and come out with a figure.
I have made a
Yes.
I
True to my best conscience, this was the agreed term, out of which this much has been deducted in my salary. Balance amount is this. ಇದು ನನ್ನ ಪ್ರಕಾರ, ನನ್ನ ಆತ್ಮಸಾಕ್ಷಿಯಾಗಿ ಸತ್ಯ ಅಂತ ಆಕೆ ಮನದಟ್ಟು ಮಾಡಿಕೊಂಡು ಮನಗಂಡು ಒಂದು ಫಿಗರ್ ಇದ್ದ ಪಕ್ಷದಲ್ಲಿ ಅದನ್ನು ಹೇಳಿದರೆ ಆಗ್ತದೆ. ಇದರಲ್ಲಿ ಲೀಗಲ್ ಬ್ಯಾಟಲ್ ಅಂತ ಮಾಡ್ತಾ ಹೋದ್ರೆ ಏನೂ ಇಲ್ಲ. ಬೀಟಿಂಗ್ ರೌಂಡ್ ದ ಬುಷ್ ಆಗ್ತದೆ, ಇಬ್ಬರಿಗೂ ಉಪಯೋಗ ಇಲ್ಲ.
I fully agree what you were last year. I made also some inquiries in my mind. What she says is that the entire transaction I have not received any money. There are so many things she says I don't want to disclose because it was the usual practice in some of the court. Before lending the money, file a suit for recovery of money, get a decree and then pay. In order to avoid any default. That was a practice earlier in some parts of the areas for which I also belong. So she
ಶಿವಮೊಗ್ಗದ ಮಂದಿ ಹಾಗೆ ಮಾಡಲ್ವಲ್ರಿ. ಅದರಲ್ಲಿ ಹೊಸೂಡಿ ಜನಗಳೆಲ್ಲ ಸ್ವಲ್ಪ ಸಂಭಾವಿತರು ಅಂತ ಕೇಳಿಬಲ್ಲೆ. ನಿಮ್ಮೂರ್ ಟೀಚರು, ನನ್ನ ದೊಡ್ಡಮ್ಮ ಒಬ್ರು ಶಿವಮೊಗ್ಗದಲ್ಲೇ ಟೀಚರ್ ಆಗಿದ್ರು, 38 ವರ್ಷ ಟೀಚರ್ ಆಗಿ ರಿಟೈರ್ ಆದ್ರು BB ಸ್ಟೇಟ್ ಅಲ್ಲಿ ಕುಂಬಾರಗುಂಡಿ ಸ್ಕೂಲ್ ಅಲ್ಲಿ. ಸೊ ಶಿವಮೊಗ್ಗ ಜನಗಳ ಬಗ್ಗೆ ನನಗೆ ಅಪಾರವಾದ ಗೌರವ ಇದೆ. ಅಲ್ಲೂ ಎಲ್ಲ ಹೀಗೆ ಮಾಡ್ತಾರೆ. That is the only way, probably.
also try.
ಒಂದ್ಸತಿ ಕೇಳಿ ನೋಡಿ. The meantime ನೋಡೋಣ legally how he can proceed ಅನ್ನೋದನ್ನ ಅವರು ಥಿಂಕ್ ಮಾಡ್ಲಿ. Let him also get instruction from his counterpart. ನೋಡುವ. But ultimately
ಅಲ್ಲ ಎಷ್ಟು ಸ್ಯಾಲರಿ ಹೋಗಿ ಆಗಿದೆ ಆಲ್ರೆಡಿ, ಏನು ಅಂತ ಕೇಳ್ಕೊಂಡು ನಾವು ಜಸ್ಟ್
ಅವರಿಬ್ಬರು ಅವರ ಹೆಸರಿಗೆ ಅನ್ವರ್ಥವಾಗಿ ನಡ್ಕೊಂಡ್ರೆ ಬಹುಶಃ ಯಾವುದೇ ಸಮಸ್ಯೆ ಉದ್ಭವಿಸಲ್ಲ. ಮಂಜುನಾಥ ಧರ್ಮಸ್ಥಳದ ಮಂಜುನಾಥನ ಸಾಕ್ಷ್ಯಕ್ಕೆ ಅನುಗುಣವಾಗಿ ಅವರು ನಡ್ಕೊಂಡ್ರೆ ಹೀಗಿತ್ತು ಸ್ವಾಮಿ, ನಾನು ಕೊಟ್ಟಿದ್ದೇ ನಿಜ, ಕೊಟ್ಟಿದ್ದಿಷ್ಟು ಅಂತ. ಶಾಂತಕುಮಾರಿ ಅವರು ಶಾಂತ ಚಿತ್ತದಿಂದ ಆಲೋಚನೆ ಮಾಡಿ ಶಾಂತಿಯನ್ನು ಕಾಯ್ದುಕೊಂಡು ಬರಲು ಏನು ಸತ್ಯ ಹೇಳಬೇಕು ಅದನ್ನ ಆಕೆ ಹೇಳಿದ್ರೆ ಬಹುಶಃ ಇದು ಯಾವುದೇ ನಾಟ್ an order based on any documents, an order based on the submissions made across the bar. Matter can be finally disposed of once for all. ನೋಡಿ Learned counsel for the petitioner is appearing through video conference. Learned counsel for the respondent.
But I am for.
Learned counsel for the petitioner is physically present in the court. Learned counsel for the respondent, bracket decree holder. Modinadal petitioner bracket JDR. Last is appearing through video conference. As admitted by both sides, admittedly, the decree holder had not produced the certified copy of the either the judgment or decree along with the execution petition while filing execution case number 98/2014. According to the parties, the original suit 406/2006 between them had entered into a compromise. But the terms of the compromise, both sides claim that they are not fully aware of. They are not aware of. The only contention of the petitioner is that in the absence of publication of the terms or in the absence of making known to the court the terms of compromise, the alleged claim made in the execution petition cannot be believed and acted upon. According to both sides, the original records, including the pleading, judgment, and decree, are said to have been destroyed by the concerned court. As such, neither party could be able to get the copies of the same. Next slide. After making the above submission, learned counsel from both sides submit that they try to find out from their client as to whether they could remember any terms of the compromise and try to find out the possibility of any settlement in the matter. List the matter on
Mela, 2 weeks. Mela.
ಅಷ್ಟೆಲ್ಲ ಲಾಂಗ್ ಟೈಮ್ ಅಲ್ಲ. ಈಗ ನೀವು ಇಂಟರ್ಸಿಟಿಯಲ್ಲಿ ಹೋಗಿ ಬಂದ್ರು ಒಂದ್ ದಿವಸದೊಳಗೆ ಕಂಫರ್ಟಬಲ್ ಆಗಿ ಹೋಗಿಯೇ ಬರ್ಬೋದು. ಇನ್ನು ಕೇಳಲಿಕ್ಕೆಲ್ಲ 2 ವಾರಗಳು ಅಂತ. ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಆನ್ 18. ಇಂಟರ್ ಮಾಡಿ ಇದೆಯಾ? 18/3/2022. The interim order granted earlier is extended till then.
35 is adjourned. Number 36, Sri Venkatesh R. Bhagat for the petitioner, Sri M.D. Raghunath for R1 and R2.
My lords, in this case, writ petitions become infructuous.
Yes.
Writ petition become infructuous, it will be dismissed as infructuous, my lords. Transfer petition filed. Now both the suits are disposed of, my lords.
Learned counsel for the petitioner appearing through video conference submits that in view of the disposal of both the suits in the trial court, seeking challenging the order on transfer of the suit, since has been the subject matter of this writ petition, the present petition becomes infructuous. In the light of the above submission, the writ petition stands disposed of as having become infructuous. Reframe ಮಾಡಿ ನಾನು ಹೇಳಿದ್ದು correct ಆಗ್ತದೆ. Yes.
Number 37.
Petitioner, my lord.
Registry B for the petitioner.
Appearing for the petitioner, my lord.
For the respondent.
My lord, the impugned order is at annexure A.
ಅದೇನಾ ಇದು? You appear for whom?
For the petitioner, my lord.
The counsel for the petitioner is appearing through video conference. Learned counsel for the respondent, none appear for the respondent. When this matter was called in the first round in the morning, one Shri Anand Muthalli, learned counsel, appeared physically in the court and submitted that he had undertaken to file wakalat for respondent in matter and that he has filed wakalat in the registry. This morning. However, after hearing his submission, in doing which the learned counsel himself was not firm, the court told him that it would inquire with the registry about he filing wakalat as undertaken, and only thereafter would proceed further in the matter. Stating so, the matter was kept by and the registry was orally directed through the court officer to ascertain whether Judge Shri Anand Muthalli or any other counsel has filed wakalat for the respondent in this petition today. When the matter is taken up at 4:08 p.m. this afternoon, the registry through court officer has made a submission that no wakalat either by learned counsel Shri Anand Muthalli or anyone has been filed for the respondent in this writ petition. Thus, it is clear, thus, it shows that the learned counsel Shri Anand Muthalli has made an incorrect submission this morning. In view of the fact that the writ petition is of the year 2017 and still continuing only for representation of the respondent who has been duly served as endorsed by the registry, while its endorsement is dated 12/10/2000. ಯಾವ ವರ್ಷ ಹಿಂಗೆ ಬರೆದ್ರೆ ನಾವು ಏನಂತ ಹೇಳ್ತೀವಿ? ಇದು ಬರ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ, ಇನ್ನು ಅಕ್ಟೋಬರ್ ಇದೆ. ಹೇಳಿ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಅವ್ರಿಗೆ ಸರಿ ಬರೀಲಿಕ್ಕೆ ಹೇಳಿ. 12/10/2020 ಎಂತ ಅಂದ್ರೆ ಸೆಂಟೆನ್ಸ್.
Representative who has been duly served as endorsed by the registry wide its endorsement date execution. In view of the fact that the writ petition is of the year 2017 and still continuing only for the representation of the respondent who has been duly served as endorsed by the registry wide its endorsement dated 12/10/2020.
Though the matter could have been proceeded further, placing the respondent as unrepresented. However, considering the nature of the petition, I am of the view that an amicus curiae be appointed for the respondent. Accordingly, ಯಾರಿದ್ದಾರೆ?
ಬೆಳಗ್ಗೆ ಇದ್ರು
ಅಲ್ಲಿ ಬೇರೆ ಯಾರಿದ್ದಾರೆ ನೋಡಿ.
ಇಲ್ಲ ಅಂದ್ರೆ ಹರೀಶ್ ಯಾರಿಂದ ನೋಡಿ, ಹರೀಶ್ ಎನ್ನಾರ್ ಅಂತ ಒಬ್ಬ ಇದ್ದಾರೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಡಿ ನಾಗರಾಜ್ ರೆಡ್ಡಿ.
ನಾಗರಾಜ್ ರೆಡ್ಡಿ ಕೊಡಿ,
ಬೇಕಾದ್ರೆ
ಫೋನ್ ಮಾಡಿ ಹೇಳಿ. ಹೇಳಿ, ಆಮೇಲೆ ವಕೀಲರು ಬರ್ತಾರೆ, ಬಂದು ವಕಾಲತ್ ಹಾಕ್ತಾರೆ, ನಿಮ್ಮ ರಿಟೈರ್ಮೆಂಟ್ ಕೇಳ್ತಾರೆ, ನೋಡೋಣ.
ಡಿ ನಾಗರಾಜ್ ರೆಡ್ಡಿ.
Accordingly, Nagaraj Reddy, who is present in the court, is directed to take notice for the respondent. Amicus curiae takes notice for the respondent. The counsel for the petitioner to furnish the learned amicus curiae the entire set of the memorandum of petition along with annexures if any, at the earliest, but not later than a week from today.
Obliged, my lord.
This is the matter immediately thereafter.
Bill number 38, Sri S.K. Acharya for the petitioner, Sri K.S. Chandrahasa for R2.
None appear for the petitioner, either physically or through video conference. No reasons are forthcoming for non-appearance of learned counsel for the petition. On 17/2/2022, this court has made the following observation. Okay. In view of the above, since the learned counsel for the petitioner has remained absent, and no reasons are forthcoming for his non-appearance, it has to be inferred that the petitioner is not inclined to prosecute the matter. Accordingly, the writ petition stands dismissed for non-prosecution.
Bill number 39 is adjourned. Bill number 40. Bill number 40, Sri S.G. Hegde for the petitioner, Sri M. Shivprakash for R1. Hanumanta Gowda, yes.
I appear for petitioner, my lord.
R9.
My lord, I appear for the petitioner in this case, my lord. Lordship may kindly see in this case, the respondent number 1 being a plaintiff in the partition suit filed an application after conducting for 1 or 2 years in the case. Then thereafter she appointed an CPA special power of attorney holder and sought for a permission to continue the case through power of attorney holder, for which an IA was filed on, your lordship may kindly see page 34, my lord. To type the page.
One moment.
36, my lord.
One
Yes.
moment.
Sorry.
You may have to fix your camera in such a way that I can see.
Sorry, my lord.
You properly. I am seeing only your band, neck band.
Sorry, my lord. I think now it is visible, my lord.
Now it is clearly visible. No problem.
Sorry, my lord. Sorry for the inconvenience, my lord.
No problem. The respondent number one is the only contesting party.
Yes, madam. Yes, madam.
Petition.
Yes, madam, because the plaintiff, she happens to be plaintiff, madam.
Yes, the counsel for the respondent is not appearing. We will appoint a substitute counsel for the respondent number one and proceed further on the next matter. The question is simple. Giving you an opportunity before disposing of the IA for filing
Yes.
SPA, right?
Yes, madam.
Counsel for the petitioner is appearing through video conference and submits that he is ready to address his argument in the matter. He submits that the question involved is simple of not giving an opportunity to the present petitioners who were the defendant number 10 to 12 in a suit for partition instituted by the present respondent number one as plaintiff. The opportunity that was required to be given to defendant was to file their objection to IA3 to an IA. File an objection to an IA filed by the plaintiff under Order 3, Rule 2, read with Section 151 CPC for filing special power of attorney. Next line. A perusal of the previous order sheet would go to show that since several dates of hearing, the petitioner has been appearing and there are counsel for the respondent, particularly the contesting respondent who is the respondent number one. Having remained absent, the matter could not be proceeded. Such an observation is made in the order sheet dated 22/9/2021 and also on 17/1/2022. Next line. On 17/1/2022, this court, noticing the absence of the counsel for respondents, has also observed that since the matter is pending since the year 2015, if none were to appear for the respondents on the next date, the matter would be taken up for consideration in their absence. In spite of above observation, since the respondents, counsels for the respondents have remained absent, I am of the view that at least for contesting respondent, who according to petitioner is respondent number one, an amicus curiae be appointed accordingly for the error of the suit. Accordingly, learned counsel Srimati Archana KM, who is present in the court, is appointed as amicus curiae. ಮುಂದಿನೆಲ್ಲ ಹಾಕಿ petitionerಗೆ ಒಂದ್ ಸೆಟ್ ಕಾಪಿ amicus curiae ಕೊಟ್ಬಿಡಿ.
I will furnish.
Archana KM ಅಂತ ಇದ್ದಾರೆ.
Yes.
Both of you exchange your email IDs or the mobile number through the court officer.
Yes.
Through the court officer, who can furnish the available number with him to either of you, so that you can exchange the, not exchange.
The copy, my lord.
Yeah, furnish a copy to her so that we can proceed on the next date. Question is simple: whether an opportunity was required to be given to the petitioner before adjudicating on IA under Order 3, Rule 2 for production of special power of attorney. This the matter on. ಈಗ ಯಾವ್ದೊಂದು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ, 11th ಕೊಟ್ಟಿದ್ದೇನೆ. 11th ಕೊಟ್ಟಿದ್ದು ಇಲ್ಲ, ಅದು ಬೇರೆ ಮ್ಯಾಟರ್. ಅರ್ಲಿ ಡೇಟ್ ಯಾವ್ದು, ಅವ್ರು ನಿಮ್ಗೊಂದು ಕಾಪಿ ಕೊಡ್ಲಿಕ್ಕೆ ಒಂದು ವ್ಯವಸ್ಥೆ ಆಗ್ಬೇಕಲ್ವಾ? ಅಥವಾ ಯು ಕ್ಯಾನ್ ಆಲ್ಸೋ ಲೀವ್ ಒನ್ ಸೆಟ್ ಆಫ್ ಕಾಪಿ ವಿತ್ ದ ಕೋರ್ಟ್ ಆಫೀಸರ್.
I will leave them. One set of copy.
Collect that copy from the court officer.
Yes, I'll do that.
That will be better. You need not have to take more pain in ascertaining the communication mode or the address, etc. of the amicus curiae.
Yes. I will furnish a set of copy to the court officer, my lord.
Court officer, in turn, the court officer would hand over copy to her whenever the learned counsel comes to the court.
Yes.
Tomorrow the matter on 28/3/2020.
Number 41, 3K Sanat Kumar Shetty for the petitioner, Arun Sham M for the respondent.
How long both of you may take? Order 39 rule 1 and 2.
More than 15 minutes.
ಇದು ಸ್ವಲ್ಪ ಕಷ್ಟ. I have a couple of enquiries to attend. If one could able to complete their argument within 10 minutes, I can hear at least one side today.
15 minutes.
10 minutes ಕಷ್ಟ ಆಗ್ತದೆ. Your IA came to be rejected.
My IA came to be rejected.
His IA came to be allowed.
I am the defendant.
You are the defendant.
I had made counterclaim.
We can make a beginning. We will hear you for 10 minutes and then we will.
But it's a suit for bearing inch.
Yes. Yes.
But the plaintiff claims to be the Yaman of the family. And property was allotted to his family under a partition dated 3110. That should take 8 at page 44. But this is how the plaintiffs claim their right over the suit property. Claim to have derived their right under a partition. But then the plaintiff at para 3 read.
Yes.
Defendants are in possession of the property situated on the northern side of the plaintiff A scheduled property. However, recently defendants have begun to assert their right over the north side of the plaintiff's A scheduled property. Hence, recently plaintiff got measured his property and very clearly identified plaintiff A scheduled property on its northern boundary line. Later on, my lord, in the body of the plaintiff, in the middle, somewhere in the middle portion,
the defendants and held an inquiry on 2014 and directed the defendants not to commit any illegal activities. However, defendants herein began to claim that the portion of the land belongs to them and they have expressed their desire to construct the building on the northern side of plaintiff issued property, claiming that it belongs to them. In fact, as on now, there are no buildings in all or any portion of the property of the defendants. However, they claim that they are paying house tax, the receipts, etc., and hence, based on that payment of the house tax receipts, it is suspected that the defendants are likely to attempt to construct a building or shed on the northern side of plaintiff issued property, wherein the fence of the plaintiff existed. Hence, the plaintiff suspects that it is quite possible that the defendants may attempt to trespass forcibly into the issued property and by use of force may attempt to dispossess the plaintiff forcibly. This is what the plaintiff makes an allegation in the plaintiff. Therefore, the allegation that is made in the plaintiff discloses that defendant is asserting title. Defendant is claiming the Schedule A property to be their property. And the plaintiff also makes an allegation by using force, the defendant may dispose. Under these circumstances, when the defendant is claiming title to the property adverse to the claim of the plaintiff, when the plaintiff makes an allegation in the plaintiff that they are claiming title, and by using force, the defendants may dispossess the plaintiff, whether a simple suit for injunction without seeking for declaration was maintained. Whether the impugned order here is on the maintainability,
It is on the merit
order or injunction.
injunction.
Injunction. Then this maintainability, we need not have to look into it.
It has to be looked into because, my lord,
Hmm.
when the suit itself is not maintainable,
Hmm.
certainly the interim relief which is sought in aid of the final relief cannot be. That is what the Honorable Supreme Court has laid down in
But
8 PS.
whether that contention was taken in your objection filed, if any, to their IA under Order 39 Rule 1.
It may not be.
If may not be, you cannot.
No, it's a question of law.
Not in this stage of, say, the challenging the order on 39 1 and 2.
But the question of law can be raised anywhere, even without pleading. Maintainability of the suit has to be decided, my lord, in the base of the arguments made in the plea. It goes to the root of the matter.
Why the court is cautioning you is for the reason, in case if the court by any chance, if the court accepts or admits your argument, well and good, succeed. Once for all, the suit would come to an end. If by any chance if the court negatives your argument, then forever and ever you lose that contention which you have every opportunity to raise in the trial court.
Okay.
That is it.
I understand. But at this stage, my lord, the court is coming to a conclusion. Prima facie conclusion, the court is arriving.
That is,
Prima facie, my lord, prima facie.
that is, court knows what conclusion, what it comes. The counsel need not guide or lead the court in that regard.
It's my
Yes.
submission, my lord. I am not the person to guide the court.
Yes.
But in support of my contention,
Yes.
in placing reliance on AR 2008 Supreme Court page 2033. From 8 SC page 2033. Paragraph 11 on.
Yes.
There are plaintiff, the general principles as to when a mere suit for permanent injunction will lie and when it is necessary to file a suit for declaration and or possession with injunction as a consequential relief are well settled. We may refer to them briefly. Where the plaintiff is in lawful or peaceful possession of the property and such possession is interfered or threatened by the defendant, a suit for an injunction simpliciter will lie. A person has a right to protect his possession against any person who does not prove a better title by seeking a prohibitory injunction. But a person in wrongful possession is not entitled to an injunction against a rightful owner. Where the title of the plaintiff is not disputed, but he is not in possession, his remedy is to file a suit for possession and seek, in addition, if necessary, an injunction. A person out of possession cannot seek the relief of injunction simpliciter without claiming the relief of possession. Where the plaintiff is in possession but is titled to the properties in dispute or under a cloud, or where the defendant asserts title thereto, and there is also threat of disposition from the defendant, the plaintiff will have to sue for declaration of title and the consequential relief of injunction. Where the title of the plaintiff is under a cloud or in dispute and he is not in possession or not able to establish possession, necessarily the plaintiff will have to file a suit for declaration, possession, and injunction. We may, however, clarify that the prayer for declaration will be necessary only if the denial of title by the defendant or challenge to the plaintiff title raises a cloud on the title of the plaintiff property. A cloud is said to rise over the person's title when some apparent defect in his title to a property or when some prima facie right or third party over it is made out or shown. An action for declaration is the remedy to remove the cloud on the title of the property. On the other hand, where the plaintiff has a clear title supported by documents, if a trespasser without any claim to the title or an interloper without any apparent title merely denies the plaintiff's title, it does not amount to raising a cloud over the title of the plaintiff, and it will not be necessary for the plaintiff to sue for declaration, and a suit for injunction will be sufficient. Where the plaintiff, believing that defendant is only a trespasser or in a wrongful claimant without title, files a mere suit for injunction, and in such suit the defendant discloses his defense and details of his right or title claimed by him, where he raises a serious dispute or cloud over the plaintiff's title, then there is a need for the plaintiff to amend the plaint and convert the suit into one for declaration. Alternatively, he may withdraw the suit for bare injunction with the permission of the court to file a comprehensive suit for declaration and injunction. He may file a suit for declaration with consequential relief even after the suit for injunction is dismissed, where a suit is raised only issue of possession and not any issue of title. This is what it is.
Yes.
The plain government itself shows, my lord, that I am claiming title over the property. And I am threatening to interfere with disposition, and there is a threat of disposition. With these averments, my lord, even according to the plaintiff, when I claim title over the property, when there is a threat of disposition, it was not open for the plaintiff to have filed a suit of simple injury. This is my response.
Stop here. Your other points of argument will continue on the next page. There are counsel from both sides present. Heard the submission of learned counsel for the petitioner. The court time is over. This is the matter wrong. When do you want?
Great.
$15,300. 15 4 ಇದೆಯಾ 16 ಹಾಕೊಳ್ಳುವ 15 ಗೆ ಪಾರ್ಟ್ ತುಂಬಾ ಇದೆ. Yes, please. 46, sir. 40. 46. Ugly.
46, sir.
For the petitioner present, since the court time is over. This matter, what the matter is about? Do not know. Since the court time is over, learned counsel for the petitioner present will prepare a short accommodation. A week's time as plead is granted, interim order granted, a delay is extended by. Yes. Agree?
43, 44, and 47. Okay. Silma 43, Sri Padma Uttar for the petitioner, Sri G.S. Prasanna Kumar for the respondent.
I'm appearing for the respondent, my lord. I have filed the memo in reporting the death of the respondent, my lord.
When you have filed the memo?
I have filed the memo today, my lord. I ascertained the date only today. That's 12/05/2021. The respondent has died.
12/05/2021.
Please, my lord.
Can you elaborate that 2021, please? 2021, right?
My apologies, my lord.
No, I just asked.
2020.
I am the person belonging to Test cricket, and you are all the people belonging to 2020s. So that's the reason I asked. Yes.
No.
Petitioner. Yes, the learned counsel for the petitioner is physically present. Learned counsel for the respondent appearing through video conference submits that the respondent died on. Can you repeat the date, please?
12th of May.
12th of May 2021. And that a memo in that regard has been filed in the registry by her today. Next time, learned counsel for the petitioner takes note of the death of alleged death of respondent, sole respondent in the matter, and prays for 10 days accommodation to make necessary application to bring the legal representatives of deceased respondent on record. 10 days time as prayed is granted. Yes.
Silma 44, Sri Joseph Anthony for the petitioner.
Much obliged.
For the petitioner's minute.
Yes, what the matter is about?
This matter is pertaining to the manner in which
the trial court has enhanced the compensation to the respondents in relation to the tree cutting matter, my lords. I am a corporation, my lords. In order to, for the purpose of effective power transmission,
Was it HTV line, high tension or low tension?
it was a high tension line.
High tension line.
Yes, my lord.
What is the diminution value that was taken?
My lords, the cost diminution value is at the rate of ₹20 taken by the trial court, my lord. It's at paragraph 15, page number 23, my lord.
Is it your case that the compensation granted for Arakanat tree or less?
No, my lord, my contention is that it is more.
How much according to you ought to have been given?
My lords, the petitioners have already paid 2,57,805 rupees, my lords. If the diminishing value, the cost of cultivation is taken at the rate of 30% per annum, my lords, the amount that would be payable to the respondent would be 2,89,170 rupees, my lords.
No, 1 minute. Diminution value for what?
My lords,
Diminution value for what?
my lords, may kindly go through, my lords, may paragraph 15 of the judgment, my lords. The trial court has calculated the cost of cultivation at ₹20 per kg of Arkanat, my lords. However, it has been held by this honorable court various judgments that it has to be calculated, the deductions of the cost of cultivation should be at the rate of 30% per kg, my lords. I'll produce the relevant judgment.
We will hear you on the next question. Cost of cultivation was required to be taken at
30%, my lords.
30%.
Deducted at 30%, my lords. However, it was only 20 rupees was deducted, my lords.
Did you not make use of the land for erecting your tower there or for drawing the lines?
My lords?
Did you not make use of the land of the respondent?
Yes, my lords.
For erecting the tower and drawing the lines?
Yes, my lords.
You have made use of.
Paid-
Have you given any compensation to that?
Yes, my lords. We have already paid compensation of ₹2,52,000, my lords. that has been accepted by the respondent.
Mr. Counsel, probably you are not understanding my question. Next date, please don't say that, say you have to seek instruction or you seek some more time to go through the file.
Yes, my lord.
It appears that the court below has awarded compensation only towards Arakanat trees.
Yes, my lord.
Cutting off Arakanat trees.
Yes, my lord.
Kindly find out whether the trial court has granted compensation towards the use of the land for erecting the towers, diminution value,
Indeed, my lord.
which is also required to be considered
Indeed, my lord.
for awarding compensation. How much of the land has been utilized by you for drawing the lines for power transmission? How many guntas of land? What is the value of the land per gunta? Whether compensation is awarded for that. If not, probably we may have to recalculate that. Come prepared on that point also, we will hear and dispose of. Yes, learned counsel for the petitioner alone is physically present. None appear for the respondent. Since quarter time is over, place this matter on 17/3.
35, 36 are adjourned. Cinema 47. Raghavendra, okay for the petitioner. Raghupathi TN for the cable respondent.
None appear, hence the matter could not be proceeded.